Laws 11062. This is Contract B, and we're into week 9 of Term 3, 2019. It is a pleasure to have you all online. Thank you very much for joining me. And if you're watching this as a recorded session and you haven't joined us for the online session live, please consider doing so. It'd be great to see everyone join us at least once during the unit. And if you haven't already commenced interaction with your fellow students, I really do encourage you to do that, to create some study groups for yourself. And the online experience can be similar, in fact can be better than having a face-to-face campus in many ways, because the communication is immediate and it's of high quality, being audio-visual. So thank you for, again, joining us this week and for your enthusiastic embracing of the course. This week or next week, you'll see the feedback button come up on the screen on Moodle. I take it you all know what I mean by the feedback button. Big red button, top left-hand corner of the Moodle screen. If you have had units in the past, you probably have seen that. You may have provided feedback. If you haven't, please look out for that. And I'm going to challenge this cohort to provide their feedback as soon as possible. I really would appreciate it. It's important for the university and it's certainly important for me. So if you have, during this week, any issues that relate to feedback, please let me know. If you have any problems, if you're encountering difficulty, if you want some further discussion about assessments or any matters of concern, please let us know, and you can use the Q&A facility, or you can unmute your microphone, use the chat facility during these live sessions. So it is important that we hear from you, and please let us know what you think of this unit. What I am very keen to do is ensure that you gain the knowledge and the expertise, really, that you'd expected from this unit before you started. Part of the assessment feedback that I provide is designed to both encourage you and inform you as to at least what I think are the important aspects of the assessment work that we do. So for the next assessment, which is due, I think, next Monday, is that correct? The 27th, which is the Australia Day public holiday. If you have any questions about that, please let me know. And I'll let you know later the sort of feedback that we have in mind. Now, I know that next Monday is a public holiday, but I will be here for the live session. So I look forward to having you join me for that session. One thing that you might have noticed about the assessment feedback to date is that I do encourage students to at least consider ethics as part of any response that you give for assessment work for me. And I'd also encourage you to think about that when you're providing assessment work for other unit coordinators. It is, of course, fundamentally important in practice. And part of the reason for stressing that in your assessment work is that sometimes it's overlooked. So in your toolkit that you developed in Introduction to Law, that I do hope that you're continuing to use, if you haven't already done so, I would recommend that you include a section that deals with ethics. Now, it may be that you have just a brief note of some of the fundamental duties of solicitors and barristers. Many of them are common sense. Many of them flow over from the ethical requirements that you have as students studying the law. Just as a brief overview, very brief, one thing that you might consider purchasing is this publication from the Queensland Law Society. It's the Australian Solicitors Conduct Rules with commentary. This is quite possibly a superseded version, or a version that has now been superseded. It's something that you'll find in many ways from the Ethics Centre, from the Queensland Law Society website, which is free of charge and publicly available. And when you look at the Australian Solicitors Conduct Rules, you might want to consider the fundamental duties that are rules 3, 4, 5 and 6. So have them as go-to rules. Then rules 7 through 16 inclusive deal with relations with clients. It includes the basic obligation in rule 8.1 that you might want to consider. Then rules 17 to 29 inclusive deals with advocacy and litigation, outlining the responsibilities of solicitors to the court and the court process, to the opponents, to witnesses, and special rules about examination and cross-examination. And in that regard, have a look at rule 21.2 that requires solicitors to take particular care to ensure that decisions by the solicitor about allegations are done with reasonable justification. It's very easy, particularly early in a career, to become a little excited and make allegations. Just be careful about that, because you should not make an allegation if it is primarily to harass or embarrass a person. Now, for barristers, the rules are much less onerous in terms of the number or the wording. It's only a very simple, very thin booklet, the barristers' rules. And have a look at the advocacy rules, rules 12 to 14, duty to the court, 25 to 36, inclusive, to the client, 37 to 40, and responsible use of court process and privilege, rules 59 to 67. For my assessment work, it's probably not a bad idea to at least just raise the issue of ethics and identify that there are no ethical issues in this matter, or if there are, perhaps point to one or two. But just be brief, because I understand that that is not the cornerstone of the assessment work, but it's useful to have in mind. Any questions, comments? All good? All right. So what we'll now do is just talk about some of the remedies. So week 9 and week 10, we're dealing with remedies, and this week primarily damages. So when we talk about remedies, I guess it's to answer the basic question of a client or of a court. What can we do about this? What's the appropriate remedy? And of course, for contract, breach of contract, there are a number of remedies that may be available that you might need to consider in the context of determining what do we do about this issue. When we think about remedies, generally, we think about those remedies available at common law, and we think about those remedies that are available through equity. Now, just a plug for a couple of things. The first is, in terms of specialist textbooks for remedies, this is one that I particularly like. I'm not sure if you can access that readily. You certainly don't need to access it for this unit, but it's a textbook called Remedies in Australian Private Law, and it's from Cambridge Press. It's very good. Another go-to text for me is Covell-Lupton, Principles of Remedies, and this is a LexisNexis publication. Now, it's I've just been doing a little bit of work in terms of a new unit proposal for this university for a subject called remedies. So, of course, this is all very interesting to me, and it would be, keep an eye out for that. It'll be an interesting unit as an elective that you might want to consider. So let's take an example that we've already dealt with in this unit. If you can cast your mind back to the work that we did on the law of mistake, you'll recall that we did discuss briefly the issue of what do we do in the advent of successfully arguing a mistake. And we know that there are different types of mistake, and so therefore the remedies do change from time to time depending on the mistake that we're talking about. But basically, in the area of mistake, we have common law remedies and we have equitable remedies. Now, at common law, which is generally, for the want of a better term, more formal and less flexible, the usual remedy for successfully arguing the existence of mistake is for a court to make a declaration that the contract is void And can anyone tell me the consequence of a court declaring that a contract is void? Usually void ab initio, meaning as from the beginning. So what's the consequence in a phrase, in a term, of a court declaring at common law that a contract is void? The answer is, it's as if the contract never existed, is the short description of that. And it's void from the beginning. So the consequence of that is that if the subject matter of the consequence of the contract was passed on to a third party, then in essence, the bona fide purchaser who was innocent will miss out, for want of a better term, because the contract initially was void, ab initio, as if it never existed. Therefore, the middle party that received the subject of the contract, which was later declared void ab initio, had no lawful power or a lawful ability to pass on the subject matter to a third party, even a bona fide purchaser for value, and therefore that third party misses out. The consequence is that by invoking that common law remedy is a very harsh reality for the purchaser. Now at equity, it's different, and you recall that the equitable remedy for a mistake is that the contract in question might be regarded as voidable, but not void. Now, equity is all about justice and fairness, isn't it? So the equitable remedy of it being voidable does not mean that if argued successfully, the contract is determined to be as though it never existed. It's, if you like, tainted, for want of a better term, with an ability of one party to seek an order of the court and to declare the contract voidable. But the court's ability is to set the contract aside. Now, from a technical perspective, when an argument is made that a contract is voidable, the party seeking to take action on that is said to rescind the contract. That is the person who seeks the court's order to set aside the contract on the basis of rescission. So do you remember some of these terms that we're talking about? As opposed to termination of a contract. For example, if you argue that a contract has been breached, then you'll argue termination rather than rescission, which is a terminology that relates to the absence of a vitiating factor. So where the courts of equity intervene, where the courts of equity set aside a contract that was voidable on the basis that that is the appropriate order, then the court will consider the rights of the third party before doing so. And in fact, even though the court might have been minded to make an order setting aside the contract on the basis that the contract was voidable, the court may refuse to make that order if there's evidence before it to suggest that the rights and interest of a bona fide purchaser for value will be affected as a result of that. And accordingly, when considering the matter of justice and fairness from a more global perspective, the court may refuse to make the order. The court may say, well, in essence, we might have set aside the contract had there not been an on sale of the subject property to a third party. But given that the subject property has been resold, for want of a better term, to a third party, then in those circumstances, we're not going to affect the title of the third party, that bona fide purchaser for value. We will therefore not make the order following through on this voidable contract. We will not set it aside. And I'm talking now about, if you like, the first contract in a chain of two contracts. The first contract might be voidable, but the court may not make the order that you seek if you're the person in the middle, if someone else is going to be affected by it. I do hope that makes sense. And the idea is that, in essence, for want of a better term, the court is trying to work out, well, who's the most innocent out of all of these, the original seller, the intermediate buyer and on-seller or reseller, or the ultimate buyer in a chain of contracts. So if a party is entitled generally to an equitable remedy seeking to set aside a voidable contract, which is rescission, then do so quickly, because if another party, a third party that might be more innocent, is affected by that, then you might lose your right to rescind the contract. And if you lose your right to rescind the contract and you purport to do so, there might be all sorts of ramifications to you. Oh, that's a lot of words. I hope that makes sense. If you don't have a quick guide in your notes, identifying what we mean by rescission or voidable, void, common law, equitable, then you should make those notes now, not literally right now, but during this week, so that you've got clear in your mind, so you can identify the right answer to the problem that you might get in the final exam. Now, are there any questions there? And I know that we're talking about remedies and damages tonight, but I'm leading into damages because we need to contrast damages with all of the other remedies that might be available. So any questions, comments so far, or are we all good? Can I move on? All good? Okay. Thank you. So you're reading this week, chapter 23 of the textbook, chapter 23 of the casebook, and of course the study guide. Now, when we argue for a remedy of damages, we're really asking for money, aren't we? So when people say, I'll sue you for all you've got, I'll sue your pants off, whatever term you want to use, generally speaking, we're referring to someone who seeks to claim damages, money. But of course, if you're claiming damages for breach of contract, you've got a causation issue, haven't you? Does anyone know what I mean by causation? In the context of an argument for a breach of contract, claiming money by way of damages, what do we mean by causation? And have you heard this term in other areas of legal practice? So what's causation all about? It's establishing the link, isn't it? So Natalie says, when the event caused the outcome. Very good. Lauren says the direct link between one thing and the other, the act and the outcome. Very good. So whenever we talk about breach of contract, whenever someone seeks to claim damages for breach of contract, that's all very well, but remember that fundamental issue of causation. You have no right to claim the damages unless you can establish the existence of the contract and then establish that the breach, the alleged breach, caused the damage, caused the outcome. And we have similar concepts in torts law, don't we? And criminal law, where you might hear of causation. So when we're talking about damages, we're really talking about seeking an order of the court for compensation, monetary compensation. And we're looking to compensate, for want of a better term, the innocent party for the loss that they have sustained as a result of what the other party have done in failing to complete their contractual obligations. So what we can take from that is that damages as a form of compensation are compensatory in nature rather than punitive in nature. What does that mean in English? Compensatory as opposed to punitive. If we're looking to, yes, Gary? No? I thought it looked as though you had your hand up ready to answer a question. Someone just snatched something from you, Gary. I could see that. All right. So when we're talking about compensation, we're really, yes. When we're talking about compensation, we're really talking about taking people back to the situation that would have been but for. And again, when you hear that but for, we're really talking about causation, aren't we? When we're talking about something that is punitive, we're talking about punishment. So damages are not involved in the process of punishing. It's not punishment or punitive. So the obligation is on the plaintiff in an alleged breach of contract issue to establish that there was a loss following a breach. And the loss is generally assessed as at the date of the breach. The authority for that is a case we've dealt with a few times, Commonwealth against Amman Aviation, 1991, 174 CLR 64. And Matthew says that when we're talking about compensation, it's like a sword shield type analogy that we talk about elsewhere in equity. Now, when a court does impose damages, the intention is to do so finally, to resolve the matter, if you like, once and for all. In practice, one of the arguments that we sometimes encounter is where there's a contract with ongoing obligations to undertake some payment, for example, in exchange for some service or product over a period of time, and there's a breach, can we argue that the contract now should be considered at an end and we deal with everything at once? Or do we have to wait until the offending party breaches now, then breaches next month, then breaches the next month after that, etc.? So when we talk about expectation, so when we talk about that issue, we're talking about to some degree, can we accelerate? So you might see that in some contracts, there's an acceleration clause. So the parties can sometimes get around this issue by predetermining the appropriate damages in the event of a breach. Can anyone tell me, and so Gary says anticipatory breach or actual, yeah. So can anyone tell me what we mean when the parties to a contract try to determine in advance the appropriate level of damages? What's that type of clause called? And the answer is liquidated. So if you see a liquidated damages clause, what we're really doing is looking at the clause that's been used by the parties to determine what they believe to be the appropriate amount of damages in the event of breach. It's predetermined. When parties come up with a liquidated damages clause, they need to be careful not to inadvertently draft something that would be regarded as a penalty. So because this is not a penal jurisdiction, the parties can't be exposed to a penalty. Now, a penalty is essentially where the liquidated damages do not represent a genuine and reasonable estimate of the damages likely to be suffered in the event of a breach. So one argument is that the damages, although they're termed liquidated, might in fact be a penalty. And if they're a penalty, they're unenforceable. So liquidated damages are a statement of the predicted estimate of likely loss. That's legitimate. That's liquidated damages. But when it comes to assessment of whether it is liquidated or not, and therefore enforceable or not, there must be some evidence as to show a reasonable relationship between the breach and the likely harm. Now, can anyone tell me the name of the case that would immediately come to mind if you need to provide some commentary in the exam about liquidated damages versus penalty? Tanya, very good. Can anyone remember? Yes, Dunlop against New Garage, isn't it? That's the case. So Dunlop pneumatic tyres against New Garage and Motor Company. It's an old case, 1915, English case, as many of them are in this era, Appeal Court 79. So what happened in this case is that Dunlop supplied tyres to New Garage. New Garage sold them on to customers. So we have, if you like, that scenario that's pretty common in contract law. First contract, supply of goods. Second contract, retail of the goods to the ultimate supplier. Part of the contract between Dunlop and New Garage was that New Garage must sell for a minimum price for each article. The contract prohibited the sale of Dunlop's products for less than the minimum price. Now, that doesn't happen these days in Australia. That would be retail price maintenance. That would be illegal under the Australian Competition and Consumer Act. But of course, in 1915 in England, it was perfectly legal. Now, in order to have some teeth, so to speak, Dunlop included a liquidated damages clause. And the damages were £5 per item sold below minimum cost, which was, in current terms, a huge amount and anti-competitive. New Garage did, in fact, sell the items at lower than the stated minimum. Dunlop sued to enforce the liquidated damages clause, and it came before the courts. And the question was, is this really a liquidated damages clause, or is it really a penalty? Now, perhaps surprisingly, the court found it was liquidated damages, not a penalty. But why? How did Dunlop succeed in that case when it seemed to be an outrageous amount that New Garage had agreed to under the terms of the contract?
It had to do with the reputation of Dunlop.
Yes, that was a big part of it. Dunlop had strategically placed itself in a position where it purported to be providing products of superior quality. They may well have, but that was the marketing position, yes. And how did Dunlop do that? How did Dunlop establish to the satisfaction of a court that it was selling items of superior quality? As is many of the case, it comes down to the evidence. Now, the reason I'm mentioning that is that there's a very practical aspect to a lot of these things. I see it in practice, and I didn't necessarily see it when I was a law student back in the 70s. And that is the importance of evidence. So when you're answering an exam question, always think about assumptions that you might make about what is actually included in the exam question, or assumptions that you'll make about things that are missing. So it may be that if you're trying to argue that in a particular case, a clause genuinely represents a liquidated damages clause and is not a penalty, you might even put in assuming that expert evidence is presented to that effect that is satisfactory to the court or is accepted by the court. So in this case, Dunlop was able to establish that because New Garage had failed to comply with the obligations, if this was allowed to continue in the future, Dunlop would suffer significant disorganisation. Its whole trading system wouldn't have to be reorganised, and the court accepted as a result of receiving this expert evidence that it is appropriate to consider the liquidated damages clause within the context of the entire marketing and management operation of Dunlop. And that's why Dunlop was successful. All right. Any questions? All good? Now, you would have seen also in the notes some commentary about expectation damages. So what do we mean by expectation damages? It's pretty common. If you're in business and someone with whom you're dealing breaches a contract, it may be that you're not satisfied with simply getting your money back or something very basic. It may be that you can argue, well, as a result of this breach of contract, I've missed out in other ways. Yes, Natalie's got it, future profits. So if, for example, you're representing a retailer who has entered into a contract with a wholesaler, and the wholesaler breaches the contract by failing to provide the goods or failing to provide the goods in an appropriate manner or a timely manner, then it may be that you're simply not satisfied with getting your money back, the deposit, because by the wholesaler breaching the contract, you've missed out on a whole lot of expected profit, haven't you? Because you had expected to receive these goods on sell them at a 30% margin or whatever the margin might be. So you've entered into the contract with the wholesaler in the expectation of making a gain. The wholesaler has failed you, and therefore it's only fair and reasonable, isn't it, that you as the retailer should be entitled to sue the wholesaler for that which you had expected to make. Again, it comes back to that issue of causation, and it comes back to the issue of expert evidence. Can you prove this? Is it provable? And let's assume for a moment that you can prove it. It's reasonable to expect that you would have made a profit in those circumstances. A leading case on this area is Zarnikow and Kufos. The spelling is CZARNIKOW against KOUFOS, 1969, 1 Appeal Court, 350. I'm not sure if this case is in the study guide or not. Are you familiar with this case? Okay. So Zarnikow chartered a ship owned by Kufos to carry some sugar for sale to merchants in the Middle East. Kufos caused a deviation of the route. It was a 9-day delay, and during those 9 days, another boatload of sugar arrived. The price plummeted by the time the ship made it. As a result, the amount that Zarnikow could sell was much less than anticipated. Zarnikow didn't want just the 9 days interest, but wanted the difference between the price obtained and the price that would have been obtained had the contract been completed. And the court said, yeah, that's fair enough. So that issue of causation that we talked about had been overcome, but that would have also been overcome as a result of the introduction of expert evidence to that effect. So Lord Reid set out the judgment. It's been used in Australia. And the crucial question is, on the information provided when the contract was made, the defendant should, or at least a reasonable person in his position should, have realised that the loss was sufficiently likely to result from the breach to make it a proper to hold that the flow of the loss flowed naturally from that breach, or at least that the loss or the type of loss should have been within the contemplation of that party. So when you're answering a question on this in the exam, it's not necessarily an exam hint, by the way, but if you were, you've got to think about this issue of causation. And what do we mean? Subheadings of causation. Was the loss something that naturally flowed from the breach, is one kind, or is it a loss that should have been within the contemplation of the party? We look at this from the objective person's perspective. So if a reasonable person could foresee the loss of expectation at the time the contract was formed, then likely the loss will be compensable. Okay, all good? So a key aspect of this we talked about is causation. But what must be compensated? There are two ways that the law of contract and the law of torts cross over. Number one, there has to be this issue of causation, and number two, there must be a requirement that the loss or the damage is not too remote. It might have been caused, but now we're really talking about something that's very remote, so it won't be compensable. So when we're talking about causation, contemplation, remoteness in the context of breach of contract and damages for breach of contract, what's the case that created the rule? Very good. Hadley's got it. Hadley. So we talk about who was the other party to Hadley? Who was the defendant? Hadley and Baxendale. Thank you. So of course we talk about the rule in Hadley and Baxendale, don't we? In an exam question, you don't need to cite the case. I'm not really that interested in the case. I'm more interested in the rule. The case was from 1854. The citation is 1854 156 All England Reports, which is abbreviated as ER at 145. So the basic rule deals with this issue of remoteness of damages in contract. It's described as the rule in Hadley and Baxendale. And the question is, for the court, can this plaintiff recover the damages? Can the court regard the damages as fairly and reasonable, be considered either arising naturally, that is in the usual course of things, from the breach, or could they have reasonably been supposed to have been within the contemplation of the parties at the time of contract, so that the damage is a probable result of the breach of that contract? You can see the two limbs there. So it's a single rule, but it has two limbs. Number one, we're talking about the loss arising from the usual course of things. We call them general damages. And we're talking about losses reasonably supposed to have been in the contemplation of the parties, which we talk about as special damages. So Hadley and Baxendale was a case where Hadley contracted with Baxendale to carry a broken crankshaft to a manufacturer who was going to use the broken shaft as a model to make a new one to replace the broken one. It was a key component, of course, of the machinery. It was a flour mill operated by Hadley, and Baxendale didn't know that the crankshaft was the only one that Hadley had. So as a result of the flour mill sitting idle for a while, there was money involved. There was a delay, 5 days, and it was 5 days without profit for Hadley. Question is, was Baxendale liable for the loss of profit? And of course, this led to the rule. And when we talk about the limbs, the first limb and the second limb have been adopted in a number of cases. So for the first limb, the damage must be reasonably within the contemplation of the parties. Therefore, two things must occur. Either the plaintiff must tell the defendant the special knowledge to foresee that loss, or the plaintiff must have learned the knowledge from someone else. And the second limb is in relation to the loss or damage which does not arise in the usual course of things. Therefore, we talk about the second limb now. An example case, again, I'm not sure if it's in the study guide, but Victoria Laundry against Newman Industries, 1949 to King's Bench at 528. Victoria Laundry obtained contracts. It needed an additional boiler, contracted to purchase one second-hand from Newman Industries. Now, after it had been dismantled for transport, it was damaged. And as a result of that, there was Victoria Laundries was unable to profit from a lucrative government contract. And the courts looked at the two limbs in Hadley and Baxendale separately. And they said the normal profits during the delay were according to the usual course of things and should be compensated by general damages, but the additional profits were not according to the usual things and should not have therefore been compensable. In some ways, each of these cases is, on the facts, case by case, and there won't necessarily be a right answer, which is why you've got the advantage of knowing that it's more the logic that you apply than necessarily the final answer that's most critically important. Another one that you might consider is Baltic Shipping Co. against Dillon. This is 1992, 176 CLR at 344. Baltic contracted with Dillon to provide a 14-day cruise. The ship sank on the 10th day. Dillon successfully argued the whole purpose of the contract was a pleasure cruise. And of course, that didn't help her. She missed out in that regard. So that's an example of where non-financial loss can be considered, and they're generally not compensable as a head of damages. Some other concepts that you might consider in your reading: mitigation. Do we know what mitigation means? Can anyone tell me what mitigation means? No? What do we mean by mitigation?
Just minimising harm.
Yep. Tanya says minimising harm. Gary says mitigate the liability of a party. So if, for example, pretty common one, someone rents a property for 12 months, then decides to buy a property 4 months into the 12-month lease, moves out at that 4-month mark, the landlord must attempt to mitigate the loss. Can't just sit back and say, well, I want you to pay for the other 8 months. The law imposes an obligation of mitigation, meaning that the landlord is required to at least attempt to find an alternate tenant to reduce or minimise the loss or damage as a result of the breach of contract. All good? So very common in these exam questions is the matter of mitigation. And the question is, to what extent and to what steps should a plaintiff be taken to minimise the loss or damage? So what steps should they have done to minimise the loss or damage, or at least not to increase it? And the onus of proof is on the defendant to prove the contention. So reasonable steps, says Tanya. So we speak of a duty or an obligation to mitigate, but bear in mind it's on the other party to prove the contention and the extent. Now, where there's repudiation of an obligation that precedes the time for performance, there may not be an issue of mitigation until termination. So it may be that one party will need to formally terminate the contract for the breach of the other, and that brings into play that whole thing we talked about a couple of weeks ago, where there's a purported termination as a result of repudiation. So you might see how that area of practice fits into what we're talking about now. Now, a fairly closely aligned concept is contributory negligence. So quite often we have another argument as to whether one of the parties has somehow contributed to their own loss. And that will also reduce the amount of damages payable. So when we're talking about damages claims, think about causation, think about the rule in Hadley and Baxendale, think about remoteness, think about expert evidence that might be used to support or at least prove an argument. Think about the reasonable person test, how that all fits in. Then consider issues around mitigation and contributory negligence. Now, of course, we're talking about, to tie in from a concept we talked about right at the start, we're talking about damages. But as a lead into some of the things we'll talk about next week, bear in mind that damages is primarily, but not exclusively, a common law remedy, as opposed to some of the pure equitable remedies, such as specific performance and injunction. So specific performance is the equitable remedy compelling a party to perform their contractual obligations. And you generally need to be pretty clear about this. If you're asking for compensation, the question is, can you do that in conjunction with specific performance, or is it an alternative? And the same sort of thing applies for an injunction. If you're seeking an injunction to refrain a party from doing something, or sometimes to force a party to do something, can that work in conjunction with damages? And are we talking common law damages or equitable damages or both? So I'm going to ask you to do a little bit more homework this week and consider 3 sections from the Queensland Civil Proceedings Act of 2011. Section 7 deals with the concurrent administration of law and equity. And section 7, if you've already got it up on your screen, good on you. If not, please find it at some stage. So this is the Civil Proceedings Act 2011, Queensland. So subsection 1 says a court must exercise its jurisdiction in a proceeding to ensure, as far as possible, that all matters in dispute between the parties are completely and finally decided. Keep that section up your sleeve, not just in Contract B, but in other subjects it might be useful, but bear in mind, of course, it only applies to civil matters, hence the name Civil Proceedings Act. And secondly, that a multiplicity of legal proceedings are avoided. Keep that in mind generally as well. And it ties in with the issue of, with the doctrine of issue estoppel that you might come across from time to time. Now look at section 8, which deals with the issue of equitable damages. So we've been talking tonight about damages as a remedy for contractual disputes. And I've been suggesting that primarily this is common law based, but not exclusively. And you'll see section 8 says, talks about equitable damages. So therefore, it is possible to claim damages in equity as well as at common law. And Section 8 says, if a court has jurisdiction to hear an application for an injunction or specific performance, then the court may award damages as well as, or instead of, an injunction or specific performance. So you might have a question in the exam where one of the parties seeks an injunction. Question is, can that party also seek damages? The party might seek specific performance. Can that party also seek damages? Well, I think Section 8 provides an answer to that. But also bear in mind that the question may require you to consider the court's jurisdiction, because it's quite clear there that not every court has the power to grant an injunction or specific performance, because it only talks about if a court has jurisdiction to do those things, then it may award equitable damages as well as those things. So do some homework on what courts have power to grant injunctions and specific performance. And that then ties in with the question of whether that court has the power to order equitable damages or it's limited only to common law damages. And then finally, the only other section in that Act is Section 10, and it talks about declaratory orders. Now, declaratory orders are not damages orders, but quite often you may have a requirement for a client to seek a declaration. Bear in mind, subsection 1, this section applies only to the Supreme Court. And number 2 says, the court may hear an application for declaratory order only and make a declaratory order without granting any relief as a result of making the order. That's only the Supreme Court. Otherwise, if there's a request for a declaration in conjunction with other orders such as damages, then different jurisdictions have that ability. Generally, in the Queensland context, generally we're talking about the District Court. All right. Lots of information to take in. Hopefully that information I've provided tonight supplements what you've been reading and supplements what you would have seen in the excellent videos prepared by Professor AJ George. We're just about ready to wrap up. Before I do, any questions about the work from this week? The second assessment that's due next Monday, the 27th of January. The final exam, the examination, any of those things? All good? Thank you very much for your patience. We'll see you next week on the Australia Day holiday, Monday the 27th. Bye then.